Welcome, students, teachers, and the constitutionally curious to the land of Luddites and another episode of the Constitution in American Life with the Friends of Publius. We want to welcome back to our program our fifth Beatle, Professor Peter Gunn, from the land of the New England Patriots, John Adams, lobsters, and maple syrup. So in today's episode, I find myself in the proverbial fish out of water moment. When I first read this question, my mind quickly took me back to 1994 and the movie Time Cop, which is a forgettable experience in and of itself. Suffice it to say that me and technological change have a love-hate relationship. But as I thought a little longer, it dawned on me that from the 19th century forward, technology has consistently presented challenges to our criminal justice system. And for the most part, how do I want to say this? The criminal justice system is generally incapable of keeping up with the rapid change in technology. And with the exception of smartphones, new technology consistently provides more power to the government vis-a-vis the rights of the accused. Maybe I'm wrong on that, so let's find out. Today, we are asked to discuss the implications of technological advancements on the criminal justice system and to brainstorm possible novel approaches to making our criminal justice system more efficient, accessible, and equitable. And to that I say good luck to our Friends of Publius scholars. So as the band Emerson, Lake, and Palmer wrote, let us start from the beginning with Professor Tim Moore. Tim, to what extent were the rights of accused persons, which were included in our Constitution and Bill of Rights, to what extent were those rights based upon the personal experiences of the framers and or the traditions found in the British legal system?
Well, I think the ground zero, since we have a British legacy here, the first answer is, well, both. And I think the British history is paramount here. And as I was thinking about this question this last week, I picked up off my shelf one of the greatest books ever written. Look at how thin this is, folks. Leonard Levy's written a raft of books about the origins of the Bill of Rights. In fact, one of his books is that title. And Levy is a great writer, is very clear. And this book, The Palladium of Justice, does something very interesting. Very, very early in the book, he says, look, the British history is paramount here. And he juxtaposes it with the continent. And he makes the argument in the first chapter that an adversarial system develops in England, whereas it doesn't develop on the continent. It's inquisitorial. And in the adversarial system, there's two great things that come out of the British tradition: jury trials and grand juries that are paramount there. And ground zero on that is Magna Carta. I mean, I reread Magna Carta this morning. That's fun. 1, 2, 3, 4, 5, 6. There are 7 provisions within the 63 items of Magna Carta that address jury issues, either vicinage issues or peers or the need for a trial. So there's that many statements in Magna Carta that relate to it. And as that evolves into British history, that evolves into this adversarial system where the jury is the umpire. And so I think Levy's book is really a nice introduction as to the adversarial system versus the continental system. The colonial context is obviously going to inherit a lot of British influences. The very early colonial charters and constitutions have jury provisions in them. It's interesting, Pennsylvania is particularly interesting, and I think in large part it's because William Penn really gets roughed up in England because he's one of these dissenting traditions, and his ordeal, he and some fellow Quakers. So it is predictable that the earliest Pennsylvania Charter of Liberties has a a very interesting and fairly thorough explanation of jury trials, why they're important. I mean, Blackstone himself, I think the quote is something like, the jury stands between people and royal tyranny. And to Levy's point, this occurs because this adversarial system, there's a commitment to that in England, not on the continent. Now, in ratification, well, let me back up. During the Revolution, there's in the 1760s and 70s, Stamp Act, Townshend Act, and one of the coercive acts, intolerable acts, the Administration of Justice Act. So you have three laws in the span of 10 years that suspend jury trials. Both Stamp Act and Townshend Act, which was kind of like Stamp Act Part 2, make provisions for admiralty courts. And then this happens again in the Administration of Justice Act, one of those four laws that were called the Intolerable Acts. So the colonials are very steeped in this British tradition of juries. And when these three laws are passed, all hell breaks loose. And so predictably, again, when it pops up in ratification, because the Anti-Federalists are afraid to death they perceive the Constitution as obliterating local jury trials, the finders of fact. They think that the appellate process basically obliterates jury trials. And so they have great suspicions about that. And in predictable form, Sentinel and Old Whig, even Patrick Henry has a speech. They are very upset because they see this bastion of safety between tyrannic power and the people is being obliterated in this Constitution. So they also have some they kind of echo this fear about admiralty courts when they say these federal courts are going to be so far away from Farmer Joe. They're not going to be able to get there, or it's just, this is a far distant court. For a lot of anti-federalists, that equals admiralty courts back in the Revolutionary days. So it's steeped in British tradition and colonial experience. Yes.
Well, I'm curious, can you give just one example of a right of an accused person that is found in the body of the Constitution or the Bill of Rights or a state constitution that is not part of the British criminal justice system of the 18th century, or the rights of accused
I'm not quite sure I understand your question.
Well, I'm wondering, does the British criminal justice system of the 18th century, is there such a thing as a Fourth Amendment?
No, but there's this long tradition of having due process. I mean, that's and that evolutionary pattern goes through this development of the adversarial system, where there's a jury and you have two sides making their case. So it's just part and parcel to the adversarial system that evolves in Britain.
So,
I mean, in addition, I think a fascinating case on juries, and it actually borders on jury nullification as well, is the Zenger trial. I know there's a lot of early American, there's a lot of teachers that kind of glance through the Zenger trial, but it's all there. The jury, can the jury nullify? There's free press issues. It's the Zenger trial in colonial America, 1735, I think, is a great example of how all these rights kind of intersect within an adversarial system that's trying to sort out. And it is evolution. And now Levy makes a point. Let's not assume just because the British developed this adversarial system that it's all unicorns and rainbows. So there are some real travesties of justice, but comparatively, Levy says the British have a much better track record with this evolving standard of due process rights.
well, I don't know, if the rest of you can help me with the clarity of the question here is, so there is no history of a Fourth Amendment protection against unreasonable search and seizure in English law.
Well, there's the Castle Doctrine. Yeah.
Okay, so there is a tradition.
Sure.
All right.
There's a tradition. Sorry, there's a tradition as far as valid warrants. mean, and the king's men and how they go about going into a person's home, right, or the domicile. So there is a tradition there in Great Britain going all the way back to Sir Edward Coke, and there's case law there out of England in terms of that, but we wouldn't call it the Fourth Amendment. It's just there's an idea for valid warrants.
Okay, so then my question is there any, I mean, looking at the body of the Constitution, looking at the Fourth, Fifth, Sixth, Eighth Amendments, looking at state constitution, is there any right that develops in the American colonies and states, all right, and then the United States? Is there any right that we wouldn't find that tradition in British common law / criminal justice, or do they all emanate to one degree or another from this broad notion that Tim mentions of due process of law?
Well, but there's press. I mean, again, how they define freedom of, fill in the blank with whatever right you want there. It's the meaning of that at that time. I mean, those principles, I think Levy's right in all of his writing that, see English common law history. But the application of what a jury means, or application of what free press means, or the application of some of the details is different. And it evolves in our system too. So I don't think there's a hard and fast, at least the way I understand it, there's not a hard and fast definition.
I think the analogy that I would use would be, I'm going to bring in a little Darwinism here, is that at one point we kind of had common ancestors. There's a commonality. So in the early colonial documents where you're talking about the Massachusetts Body of Liberties or Fundamental Orders of Connecticut, there are coming from their British heritage, but as the evolutionary process takes hold in the colonies into the states, you're going to see, and then into the Constitution, you're going to see an evolution of these rights get fine-tuned. But I think somewhere back on the criminal justice tree, so to speak, we had common ancestors. Does that sound right, Tim?
Juries seems to be, I would vote for juries being the clearest articulated in British history as it being stated as such.
Well, Jack Rakoff has said that that the two most important rights that the colonists got from Magna Carta were the right to jury trial and the right to not be taxed without their consent. So, and you see that you play out throughout the colonies.
So with Tim, I was looking for some historical kind of development there. Chris, with you, I'd like to look at principles, and if you could identify what you see as some of the fundamental principles of America's criminal justice system that may or may not be impacted by technology. And so here's a principle, just one of them, that I would, that is, the punishment should fit the crime. In our notion of fairness, all right, we have this principle that, we shouldn't have excessive punishment there. That's a principle. What other ones do you think are part of the American tradition?
Well, Tim mentioned the adversarial system of justice, right? And I think a procedural due process. Students, obviously we've talked about substantive due process. Good luck with that. But procedural is much easier. From the minute the police officer pulls you over to the minute you walk out of court or the jail door slams behind you, there are the steps that the government must follow. And it's the amendments 4 through 8. And David, you mentioned the Eighth Amendment. But then in the adversarial system of justice, there is a presumption of innocence. That is, I think, one of the fundamental keys of our system. And I think every student knows this, you're innocent until proven guilty. And in that system, the burden of proof is on the government because the government is the one bringing charges against you. So the burden of proof is on them. You do have the right to remain silent. I know that's part of the Miranda warning these days, which, thanks to cop shows dating all the way back to our young days, most kids can recite those, but you are not compelled to help the government make their case against you. So you have the right to remain silent. And again, the burden of proof in the adversarial system of justice is on the government. They're the ones bringing charges. You're protected in the Fifth Amendment from double jeopardy. The idea that the government gets one bite of allegedly until it's incorporated, and which it wasn't incorporated until the 1960s maybe. Uh, so you're allows you to protect from double jeopardy. So these are some of the basic fundamentals of procedural due process, starting with the Fourth Amendment, as you alluded to, David, with search and seizure. Was the evidence obtained legally, all the way through, grand jury presumption, indictment, right to an attorney. So all these rights that we see 4 through 8 are parts of the steps that the government must follow in the adversarial system of justice. Now, the second part of your question deals with technology, and technology is a much broader, boy, that's such a broad category to define, because my goodness, I mean, we could go back to when fingerprints were just started, people being able to take fingerprints, or the very early days of DNA, or surveillance, putting a wiretap on a phone. So technology is a much broader topic. But I think my concern would be that technology is introduced, and I think Tim alluded to this, or David, you alluded to this in your opening, that when this technology is introduced, does it tip the scales in favor of the government? Because you have all these protections from the government because they have a lot of resources and most of us do not. So we are protected from this an overreaching government through these rights in the Bill of Rights. Of course, it's again taken time and it's taken incorporation to do that. But the concern would be for any new technology or even old technology, does it tip the scales in favor of the government? And that would be the concern there. And some of it could.
Well, and yeah, I think, I made, I presented my point of view that I'm hoping that you guys slap me around a little bit on, is because I would make the argument that every step of the way, it initially gives an advantage to government. But the spirit of my question is, I'm hoping in the next, 45 minutes or so, again, so are all of these principles impacted by technology, or some of these principles, new technology has really no impact or very little, if any? Again, the right to representation, the right to an attorney. Does technology in any way, shape, or form impact the right to an attorney? So that was the spirit of where
Right. And I don't know that again, the word technology is just too dang broad. It's just, I mean, because we go through the ages of technology, and you know, the telephone was technology.
Well,
But
yeah, I know the question says technological advancements. Is that still too broad?
yeah, of course it is, because it
Okay.
depends on the era that you're in. But one of the things that Tim mentioned too made me think of when I was doing some research for this evening. Believe it or not, I actually did some. Um, was that during COVID, having remote court cases, and through Zoom, or through what, like the method we're doing. And I'm thinking, and there was some writing about that and how that's probably not quite as thorough as obviously face to face, as we've learned through about teaching and everything else. Doing it this way is convenient, but does it skew things? And I think there could be an issue with that. But we got to remember too, and I don't want to jump the gun here, but we're talking about trials, and students, you guys probably know this, less than 10% of all criminal cases in the country go to trial. So, I mean, trials themselves are a much smaller part of this discussion, I think.
Right.
I wonder whether the fundamental, I tend to think a fundamental principle we inherited from the tradition in England is, I mean, you look at Magna Carta, as the principle of property is all over that thing too. How the government can take or cannot take. So there's all kinds of due process rights as related to property in Magna Carta. So I wonder if the cell phone, I mean, the cell phone is no longer a phone. I mean, yeah, it's a phone, but I think that principle of, private property is, I mean, some of these cell phone cases are quite fascinating to me, and how they're configured as, is it is it a phone or is it a filing cabinet? You know, it's
Well,
like it's,
Riley v. California is, Chief Justice Roberts made it pretty
yeah,
clear in that case that the police officers will need a warrant for the phone.
yeah,
But what's even more fascinating, and I'll put something in resources for this, is about digital assistants. So when you have a device that is in your home that's constantly listening for that wake up word,
yeah,
will police be able to go to the cloud and get information? And I'll put in our article for the American Bar Association, which is really interesting in terms of that, which I think actually goes to the bigger issue here is not necessarily trials, but I would argue that it's information gathering, evidence gathering is probably the bigger issue in terms of technology and
yeah.
the expansion of government power.
Yeah. So Professor Williams, I would argue, making again one of my many arguments in this question, I would argue that when it comes to low income and people of color, the idea that America's criminal justice system promoted fairness and equity at any time in our history is part of the exceptional myths we tell ourselves. Do you agree or disagree with this perspective?
Yeah, I do agree with that, and I appreciate you giving me the non-technology question. That's awesome. Um, and this is a great question, David, and the students.
Well,
You're
the students are asked to deal with equity
Sure.
and justice here.
Yeah,
And my
so
thing is, again, does technology matter? Because we've never had what I would call, a fair system of justice.
Sure.
I'm sorry. Go ahead.
Yeah, so let me give a little bit on this, and students, you're going to be able to find a lot of information on this on your own. I'm sure a lot of you know about some of this, the disproportionality, but I would start, David, with your question of, let's think about what the first mechanisms our police are in the United States. And as students, as you probably know, from my research, right, the first police are slave patrols in the Carolinas in the early 1700s. It's not until 1838, Boston, by my research, is the first city to have a police organization, like in
And
their
if any city needed it, was Boston.
exactly right. And then quickly New York and Philadelphia followed. But
Sorry, Peter.
Welcome, Peter.
so the the origin of having a criminal justice arm, right, starts with slave patrols. So I think that that's important. I would also, in terms of the poor's, I don't know, engagement with law enforcement. One of the things that we inherited from England as well were Elizabethan poor laws. And these were laws that you could be fined or put in jail or forced to work if you were simply defined as a vagabond or if you were being idle. Let me just read briefly. You'll like this, Peter. This is from Maine, but Massachusetts apparently had a similar law in the books in 1833. It says all rogues, vagabonds, and idle persons going about in town or country begging will be put into a poorhouse where they'll be forced to work. And there was a lot more graphic description of these folks there, but I'll stop there. So we have this history of police officers, police units kind of coming from slavery. We have the poor laws. And then we fight a war over slavery, and the 13th Amendment, students, as you know, says that slavery is abolished except as punishment or punishment for a crime, right? Which has become for many excellent books on this. Michelle Alexander's The New Jim Crow is the one that's gotten the most press, of how the prison system has just become another way to sort of penalize people because of race, and to be another way to enforce black codes and Jim Crow laws. So we get to today. In the United States, as of 2024, is the sixth country on the list in terms of per capita, per 100,000 people we have in prison. El Salvador is now leading the pack. We are following countries like Rwanda and American Samoa. We are the largest, like the only democratic country that's in in the top 10 in terms of the proportion of people that we incarcerate. And then you look at that and you look at who's getting incarcerated, and it's people who are largely poor and people who are of color that are disproportionately in the criminal justice system. So yes, I do agree with your statement. I think it comes from this kind of historical origin point. And I'll just finish with something that in San Diego, we talked to students about the tale of a trolley ticket. In 2014, 16,000 people were given citations for riding the trolley without a ticket. That increased to over 60,000 in 2018. Many people getting these tickets are people who are unsheltered or poor. The ticket to ride a trolley in San Diego is $2.50. If you get a ticket, you can either pay the fine, which is $193, or you can contest it up at a court in Kearny Mesa. Most people don't contest. Most people don't pay it. By the time it gets to the third offense, the third warrant coming down for you, you are going to owe over $500 plus $300 in court fees, and there could be a warrant for your arrest for one trolley ticket. San Diego has the bad reputation of being one of the cities in the United States that has that tickets people the most for trolley violations. So even in something as local and as contemporary as using mass transportation, I think we find that it is people of color and people of low income who are disproportionately affected by the larger criminal justice system.
So, Peter, it seems to me that all of the technological changes that have occurred in my lifetime provide more power to the government against the individual, especially on the front end of the criminal justice system, which I think Tim has identified as we look at search and seizure, Fourth Amendment cases, possibly some Fifth Amendment issues there, kind of thing. And I'm hoping maybe we can talk about cameras out there in general society as part of this. But do you agree with me at that observation that that most of the technological change that we've experienced provides more power to the government, at least initially?
Yeah, I do agree. And I think there is a rejoinder to that. But just to pause for a moment, I want to go back to something just for the benefit of the students that Professor Kavanaugh said a moment ago about the percentage of cases that ultimately go to trial. And it is remarkably small. It's 10%. But if you get your jury summons, you want to still go, because it's the presence of people in the jury room that often motivates the criminal justice system to resolve cases before so even if you don't serve, this is one of the tricky things about statistics, right? 10% seems like a really small number, and people think, well, what's the importance of jury trials and serving on juries? It's important that you go, that you be in the room, that you be ready to serve. So sorry for the side note there, but I always, we would often sit in the jury room in our little Hampshire County court system, and the attendant would come up and down the stairs saying, we're getting there. We're getting there. And sometimes that meant we would go into the courtroom and we would serve on juries. Other times we learned that the cases had been resolved. But
well, can I ask you, Peter, since you brought it up, and Chris as well, it seems to me that this notion of so few jury trials out of the total number of, well, in and of itself is evidence of a problem in our system, because plea bargaining is the numbers of plea bargains by percentage is the poor and people of color are plea bargaining in many cases, according to research, in which they probably haven't committed a crime, but the system is so geared against them. Isn't plea bargaining in and of itself evidence of an unjust system?
I can give you a little history on this. I mean, in British history, the accused had to pay. I mean, there was a lot of, quote, plea bargaining in British history too, because the accused had to pay for the jury, had to pay for all these things. And so there was a lot of plea bargaining that went on before the actual trial back in British history. So it's not a new thing that the number of trials versus the number of, quote, plea bargains, that goes back a ways. And now to the American context, I'll let you guys speak to that.
No, I think you're correct, David and Chris. Please correct me if you disagree. That I think the desire by the state to be efficient, to save money, to have relatively high rates of convictions, And the sheer weight, imagine you're the accused and you're there in the room with all of the resources, both literally present in front of you and those you imagine behind every door and every glass window in the room. The pressure on people who don't have a lot of resources to agree that they might have done something in exchange for a lesser consequence than what they were initially brought in, it has to be immense. It has to just be incredible, and it has to produce the kinds of results that you're talking about. I don't know, Chris, if you wanted to comment further on that.
I think I would agree with everything you've just said, Peter, for sure. But I think it's also indicative of the amount that our criminal justice system of cases that they have to deal with, because you have public defenders who have what they call meet and plead, right? They'll meet their defendant and then they'll plead their defendant because they're so overworked and overburdened by their caseloads and so underpaid that it becomes really tough. So in addition to what Peter said, I think it's also indicative of the volume that local courts have to deal with. And so, I mean, the wheels of justice are designed to move slowly, but this is one other way for this to move it along to save the state money, as Peter said. But it's also indicative of the amount that local systems have to deal with.
And I know that David, this isn't directly onto the question still, but just to sort of triple down on this, in Gideon, the court said, everybody should have an attorney and that the state will provide one for you. So by law and by theory, the adversarial system that Tim was talking about earlier operates effectively when both sides have, the advocates there. But the reality of the resources, and that's a question for a different conversation down the road, but they're just enormous, and they speak to the issue that Professor Williams was pointing out, which is that if you're poor and you're accused, you stand a far greater chance of being convicted, independent of whether you're truly guilty of what you've been accused of, than if you're wealthy and well-resourced. The other caveat, David, I would have to say is I wasn't quite sure how far back to go when you said all the technological changes that have occurred in your lifetime, but I chose to limit the technical innovations that we would discuss to those.
Put it this way, I think the TV show Dragnet started the same year I was born.
Okay, well, Peter Gunn, the TV show Peter Gunn, was the same year I was born, so I'm right there with you. I do, the reality is that initially, most technology benefits the power of the government, whether it's the radar gun that improves the ability of the police officer to measure the speed that a car is traveling, whether it's the when anybody who's been through an airport understands how technology can inform the TSA about more about you than perhaps you or anybody in your family wants to know. But I also wanted to say on this question, not so fast, because as I thought more and more about it, I realized that things like body cameras, things like cell phones, really do a lot to redress the balance in favor of the citizen in ways that weren't true 20 or 30, 40 years ago. DNA analysis is another medical technological innovation that has done a lot, sadly, often far too down the road after the fact, to remedy errors in the criminal justice system. I mean, I think it's just about once a month that I see a story about someone who has spent decades imprisoned in the criminal justice system, only to discover that with the application of new technology and new innovations in research about DNA, that they couldn't have committed the crime. And so I think that your question is a good one. I think most people go to the conclusion that the government is gaining. But look at what the cell phone has done to discipline, or at least document, the misconduct of the police.
Yeah.
From the famous George Floyd If you're old like me, Rodney King, things that get captured on video did a lot to force us to have a reckoning over the way the police treat often it's people of color, but just in general. So I do think that the other piece that's out there, and this is again depends on your resources. If you have access to a legal organization that can do the kind of artificial intelligence meta-analysis of the criminal process in a town or a county or a state, powerful evidence can now be introduced in court to suggest that there are some systemic tendencies that work against the accused. And once they're brought up, they serve to make the criminal justice system more constitutional. There's more limit on the body that has power. And the last piece that I would say in relation to this, and I really liked this article, it's in the resources, and students, I would encourage you to look at it. It's an interview between Andrew Cohen and Owen Kerr. Owen Kerr is a professor of law at the University of California at Berkeley, who's written a lot about the issues related to this question. And one of the interesting topics that comes up towards the end of the interview is, what if technological innovations make it easier for the government to be less intrusive into your rights? Say, for example, when they're doing a search, right? Let's say they want to do a search. In the old days, they would come into an office like this and dump every drawer and open every piece of paper and every envelope, and the place would look like a tornado had blown through it, all in search of one thing. Well, if they want to find something specific on my cell phone, for example, that they believe is related to a crime, what if Google or Apple or whichever company it is can provide a laser type technology to facilitate that search so that it becomes far less intrusive on me? Lots of extraneous information to the case that would have been found 5 or 10 or 20 years ago in a human-based search now may be avoidable. And what Professor Kerr suggests is, it's a question, and I think it's a great question for students to talk about, is, does the Fourth Amendment require that the state use the least intrusive method? I think he even, I wrote it down, I think it's the MPPW, right? The most protective of privacy way. It's sort of like a strict scrutiny approach to when your privacy rights are going to be affected, that the state has to show that they use the least burdensome method of acquiring the information that they are lawfully allowed to seek because they've gotten a warrant and all the rest. And I think it's a really fascinating discussion about where we might be able to go. And instead of seeing technology as always immediately producing an increase in the power of government at the loss of individual liberty, maybe the possibility will come about where some of this technological innovation will allow the government to do what it needs to do, but to do so in a far less intrusive way.
Well, I want to focus in on one aspect of surveillance, and my wife and I are fixated on British television, British crime and drama programs, and and even there's some that deal with the Netherlands and with France, and the use of cameras, all right, in the public sphere. All right, I believe they call it CCTV in England and probably elsewhere on the continent there. Is quite expansive. In fact, England, something like doubled or tripled the number of cameras during when they hosted the Olympics. And instead of civil liberties groups agreed to it for that moment because the government kind of implied, well, we'll take many of those cameras back once the Olympics are over, and that never happened. All right, but it was fascinating to me that in reading about that the American Civil Liberties Union and other civil liberties organizations are opposed to using, all right, a lot of cameras in the public sphere, all right, to make our streets hopefully safer and to give us access to information. I'm wondering what you think about that, Peter, on the notion of CCTV in the American culture.
Well, it's useful to start with that British example. When I traveled to London for the first time in the early 1990s, events on the island of Ireland and the 6 northern counties of Northern Ireland were really hot. And whether it was precisely true or whether it just sort of got passed down as lore, we were informed that when you walked the streets of London in 1993, there was never a moment that you weren't on camera, that at least one camera was watching every square inch of the public space in that metropolitan community in the name of security, to avoid, or they hoped to deter, potential political action. I think that the challenge, and this is where Kashmir Hill, I think a couple of us have put information of hers into the resources, and students, I will confess that, this question, I was inspired to think about this question this past September when I heard her on an interview with Terry Gross talking about the way facial recognition technology, and in particular, one company, was showing up all across both the private and public sector. And the challenge that she quickly pointed out, the book that she wrote is Your Face Belongs to Us. And this company would scrape, I love the terminology, they would scrape every publicly accessible social media site, anything public on Facebook or Instagram or TikTok, wherever you were. And they built this incredible database, in some cases having as many as 100 or 200 pictures of each individual person. So far more than the 300 million people in the United States, far, far more pictures than that. And they would use this technology, they would pitch this technology to police departments as ways to help identify people who are engaged in criminal activity. Pretty quickly, some of the problems emerged. The technology being designed by people who look like the five of us, and being really good at recognizing the five of us and distinguishing Tim from, David from Chris, from Peter, from Mike, wasn't so good at discriminating in other ethnic groups, gender, and age. And so all sorts of well-publicized false accusations came out, and the algorithm had to be reworked and reworked and reworked. But a lot of lives were damaged in the interim, and it's even became notorious. I think it was 2 Christmases ago where James Dolan of the New York Knicks ownership group was using facial recognition technology to keep lawyers out of Madison Square Garden who were part of firms that were engaged in cases against them. And Kashmir Hill even tells the anecdote of where she bought the tickets, and she and a friend went to a Knicks game, and as soon as they got through the metal detectors, they were stopped. And the woman was told, you got to hang out a minute, and she stood there, and 30 seconds later, manager came over and said, you can't come in the building. And that fast, the technology was such that they could see her. So I think that goes back to your original question. The government empowered, this company that was successful in this made a big pitch to Hungary. I don't think we have to, wonder why the Hungarian government might be interested in using facial technology, recognition technology like this. So cameras are, I think, kind of the poster child.
Well, you narrowed that down to facial recognition. I'm just looking at general CCTV. To me, I don't know why we don't have more of it to serve the public interest, and the common good, because I don't see in a public, on the streets of America, I don't see how cameras are intrusive or a violation of our civil liberties. Yet I seem to be in the minority when it comes to civil liberties organizations.
Yeah, and I think, there was a small business in my town that put up a camera in their shop window that captured a major intersection where there was a lot of activity in town. And at first people thought, oh, how cool it was to watch it. And then very quickly, a lot of people were like, well, how not so cool to not know that you're on camera, and then to have the world have access to it. So maybe, David, the concern could be minimized if we get everybody to presume, what do we teach our students? World Wide Web, anything you post ultimately could be available to everybody. Maybe we should adopt the view that anything that you do in public can be accessible to anybody in the government or in the community. But one of the things that Professor Kerr talked about that's really important is adjusting the laws so that we can preserve the status quo level of expectation of privacy that somebody would have enjoyed when the Fourth Amendment was drafted. And I suspect that in the 1780s and 1790s, most folks thought that as they traveled along the country road with their herd of sheep going to market, that they weren't going to be, known, and whatever they did en route, they weren't going to be known to everybody in the community. So I'm in the camp of understanding why. I mean, the Boston Marathon bombing, a lot of the work there was resolved with the help of cameras. And
most of them private business cameras and things like that. They weren't governmental.
right. And the Supreme Court has told in the Jacobson case, I believe, somebody can check me on that if a private company captures something that you're doing, that they can share it with the government without it, warrantlessly. It doesn't need to have a warrant. And given the innovations that some states have recently adopted about deputizing private citizens to carry out legal functions, can you imagine turning loose every citizen in a community to be a tech sleuth to discover information online about their neighbors and then sharing that with the police if they thought that I guess, David, what I'm trying to get at is I think we lose something as a community. I mean, part of living life is that there's a risk. And I once had a student say to me, and I think you guys have all heard variations of this, security matters to preserve a way of life up to the point that you sacrifice that way of life. At which point, what are we securing? And I think we're still figuring that out as a society. How much of our privacy do we want to sacrifice for the tranquility and defense that the preamble of the Constitution promises?
Gentlemen, you want to jump in? Because I see that I don't have any expectation of privacy in the public sphere. And therefore I see no problem with it as long as it's the public sphere, and we can go into some other areas, but I'm just curious, Mike, Chris, or Tim, your thoughts on.
I know Mike had something earlier.
Well, yeah, I think the politics of law and order means that it's much easier to set these things up and to have it lean in favor of the state and of the criminal, like those who want to prosecute, than it is for ordinary citizens. So I was thinking not less about CCTV and more like we talked about body cams. And I'll share in the resource notes. There was a podcast, the Daily Podcast, talked about how body cams, there's very little citizen oversight over actually when you get access to them and how they're used. So everyone thought this was going to be super positive in terms of protecting people's rights. And it's turned out that in the nitty gritty of it, I would argue in the politics of law and order, it's much harder. Like once you allow this technology in, it's much harder to make arguments to rein it back. So I imagine the reason why civil rights organizations are hesitant about CCTV is because they've kind of seen this picture before. Like once you allow the state to have access to this information, can we really trust that citizens are going to be able to rein it back in?
I know that Ring, for the proliferation of Ring doorbell cameras, just this year, actually, just a couple of weeks ago, they're no longer going to allow police to request doorbell camera footage from users. They're going to have to obtain a warrant for that now, because there was an app called Neighbors where you could share information in a neighborhood setting, and police agencies would go out and contact people to share their footage, right, which would help them in their investigation. But now they can still request, but now they have to use a warrant because Ring is no longer voluntarily sharing that recording from the proliferation we have of Ring doorbells. David, I'm back to your original point. I guess there's I'm walking down the street, I'm going for my walk today, trying to get some steps in, and I look around and I want to like lean over into the snot rocket or something because it's kind of chilly out, or I want to, my boxers are creeping up a little high, whatever, right? Well, I'm just, you look around, it's like, oh, okay, I'm gonna, do whatever, and there's nobody around. So I think, okay, yeah, I'm out in public, I'm going for a walk, I'm minding my own business, but should I have an expectation of privacy? And I'm torn here because, whether it be the Iron Triangle in London or, walking down the street in Bismarck, North Dakota, should you have, so your argument is that you lose all expectation of privacy once you enter into the public domain. And I'm not sure that you should. I don't know for sure though.
Yeah, I'm just looking at, and maybe it's specific to where I live and our experiences, but I'd much more prefer that the streets of the community in which I live are as safe as we can possibly make them without what I'll call excessive violations. And again, I don't see England as falling into a tyrannical system of government with their system of CCTV, especially within the city of London.
But
There. Yeah, Mike?
yeah, but China has. I mean, a few years ago,
Yes.
I walked around China, and I walked around not doing snot rockets or fixing my briefs, and it still was like weird to have all these cameras on me. And so I think that I think there's something to be said of what Peter was trying to bring up of just this sense of like securing to one extent. I mean, has Bakersfield had a crime wave that I haven't heard about? I mean, are things really that chaotic?
Not since you moved, Mike.
Yeah, exactly. I mean, are things really that chaotic on our streets that we need cameras on every block to watch everyone? I just I don't know. And in China, it's disturbing of how
Well,
much.
first of all, again, that's a good one, Mike. And let's throw China into the equation here.
Yeah, but that's
Even
the backdrop
even
of this. I mean, that's the backdrop of our discussions, though.
No,
You
even
always have
before
that foil.
cameras, China didn't need cameras to surveil you, Mike. All right, so instead of cameras, it was two agents of the state were following you around.
Yeah, and
And
that's what Martin Luther King and others had going on with them as well, right?
Right.
I mean, I think there are just more bad uses for this than there is the good that you're going to get out of it in most communities. No data for that.
body cameras, drones flying over my house, I'm going to agree with you on. All right, because to me, that's not the public sphere per se. If they're looking into my back yard, or they're looking through windows with infrared camera and those, all those kind of things. I'm looking at basic CCTV. All right, on the streets of America, and I don't see the intrusiveness because I don't think I have an expectation of privacy. So somebody sees me, scratching my crotch, so what? Again, or the government does. Now, if they criminalize that, all right, then yes, I'm with you. Okay, I'm with you. If they criminalize me scratching my crotch out there on the street,
The things the
that might fall into a First Amendment obscenity category.
I'm
things
fully
the-
clothed.
things the fops do when they go for walks. That's going to be the next bingo card.
I think, David, it's a good question. One of the notes that I wrote in my preparation for this is, we've got the big 5 goals that come out in the preamble, and they don't always sit well together. It's hard sometimes to, we have justice, tranquility, defense, welfare, and liberty, right? Those are our 5 purposes of government. And sometimes a couple of them are in tension with each other, and that's why it's good for students. I mean, I think you're asking a really good question for students and teachers. I would love to have the conversation, because I don't know that there is a right answer or that there has to be a right answer, but I think having the conversation intentionally and in a civil way can do a lot to make sure that the legislation that we do get is better legislation, and it's more likely to be followed, and it's more likely to be effective than otherwise. But I think you're asking a really good question, hard question.
Well, I think there's a correlation here, but I think of my boy James Otis, and we always bring up the idea that, about Fourth Amendment and the idea of a valid warrant and the whole idea of what was going on pre-revolution in the 1763 case. And students will, I say, well, if I'm not breaking the law, what do I care if the cop comes in, right? And then you're trying to explain to students, well, no, there are certain things that the police or the authorities or the government, there are certain places that they don't belong without some type of due process, without some type of valid warrant. So the idea that the authorities, the government can have carte blanche to, surveil every section of open air seems to have a somewhat of a chilling effect, perhaps. And maybe that's what it's designed to do, because I'm sure in China it has a chilling effect.
Eh.
I think there's a correlation between those examples that there are certain places that the government doesn't belong.
I would invite students, David, to go back and look at the debate that I think occurs between Antonin Scalia and Sandra Day O'Connor in the case involving the drug testing of high school athletes. I always reverse it, Acton v. Vernonia, because I think in their discussion, they get at, the advantages and disadvantages of treating everybody. And I realize that you choose to play sports, so your expectation of rights are different. But they have a really good conversation back and forth, the way those two great minds could, about this idea of individualized suspicion before we surveil you, as opposed to a presumption that somewhere out there might be criminal or some form of negative behavior going on. So we're going to surveil everybody. And it's a good example. It's a good case. It's a good Fourth Amendment case for students. It may not be precisely related to this one, although, a whole lot of technological innovations seem to be going into avoiding getting positive drug tests when I was in school. So, maybe.
Well, just one other thing quickly. I think that, law enforcement and criminal justice, they're increasingly using AI and ADM, automated decision-making processes. And the idea is that they're profile people as criminal to predict their actions and assess their risks of certain behavior. So, they're using some of this information, and I don't want to get too far ahead because I think I know what you're going to ask Peter coming up. But I mean, they're starting to use some of these algorithms now to predict behavior, which is shaky. It becomes, I don't know, that's a shaky ground, I think.
Well, as I was going to say, and you're right, but as a coach would at halftime, if things have kind of gone off the beaten path, we're going to make an adjustment here and jump to that question of predictive algorithms. First of all, I had no idea what it meant. Once I read a little bit about it, then I thought of the film with Tom Cruise, The Minority Report. And I guess my question to all of you, but we'll start with Peter, is that where we're headed? Is that where the technology is headed? And therefore, is that the reason we should be concerned? And I mean, it's, and Chris has kind of brought up some of this, but I also look at sentencing. All right. We are using algorithms to decide sentencing of crimes there. And is that all right? Are we okay with that? As well as this predictive algorithm of, again, it looks like the Department of Pre-Crime in the Minority Report. So yeah, I'll leave it at that, Peter. Is that where we're headed with this technology?
I think that's a legitimate fear. The film that I thought of actually, was more recent, was Mindhunters. And in the sense that those guys did, they were creating algorithms one interview at a time. And it was very human generated. And as you point out in the example that you brought up, we're going to get ever more sophisticated in the creation of these algorithms. I think that we would be wise to be cautious about how much medical information we want to share in the name of, I mean, we've just had a real-time experiment in watching our society come to grips with a disease phenomenon in dealing with COVID. Sure, I bet some AI analysis would be really helpful in getting certain populations assistance more quickly, because the medical analysis would suggest that they were more at risk. But there's a really thin line between that and saying, well, we're going to segregate this community of people because of this biomedical information. And I think that's an extraordinary violation of people's privacy rights. And, you know, we are ultimately a nation of individuals and individual actions and individual responsibility and individual accountability. And I know it's harder and it's more expensive, but I think we come closer to getting justice when we do it one case at a time.
Chris?
It's actually Minority Report is a book that was written in 1956, a sci-fi book that Steven Spielberg felt compelled to make into a movie, I think because of perhaps maybe what was going on in our war on terror. I'm reading between the lines on that, but I know it was a book in 56, a sci-fi book about the precogs and being able to predict crime before it happens. So it's an interesting idea. And I think this, you know, some of these algorithms that you see being used for that predictive behavior is a concern. And I think, was it Clearview? I think, Peter, was the name of the AI company that was doing the scraping of the photos. You know, interesting. And so there are places, European countries, Canada, and cities and states that are actually trying to limit that availability, because you told the story about Kashmir Hill going into Madison Square or into the Garden. The people that own Madison Square Garden also own something in Chicago, a venue in Chicago, and they can't stop people in the city of Chicago because they have laws that prevent them from using that. So you can actually opt out of them gathering your information as well. I think this steps into the next big issue of rights, one of the next big issue of rights, and that is the right of your data. Do you own your data, which includes your image, as your image flies around on the internet and maybe posted by your friends on Facebook or your friends on Instagram or whatever it may be, sharing photos. Do you own your own image? And I think that becomes an issue. And I think, wasn't there a documentary on Netflix a couple of years ago? Was it called The Big Hack or something like that? I've forgotten about that. I didn't.
Yeah.
I maybe will look that up. But I think that could be the next big issue of rights, and that is your right to your data. Do you own your data, including your image? So I'm not sure where I'm going with that, but I do think that there's a concern that by making it automated, people feel it's more fail-safe, but it's not, because there is still the human element to take into account. And I would agree with Peter. You know, we are a nation of individuals, and we think individuals should be treated as such.
Well, you know, so Mike, and this to all of you, time is kind of always our enemy here. We can go on and on here, but we need to kind of bring this to a close. The students are asked about potential, I guess, you know, what they phrase as novel ideas that could make the criminal justice system more efficient, accessible, and equitable. And other than specific statutes that might deal with this threat of technology in whatever form, the only thing I can think of, Mike, that's novel is to equalize the spending, all right, for prosecutors and defenses. And I think it was brought up, I think it was by you, Mike, or, you know, I forget, or Chris or Tim, or somebody brought it up about and I know in my community, the disparity between the DA's office funding and the public defender's office is just, you know, it just shocks the conscience to see that. And so to me, the one novel thing is just to equalize spending in our system on the, you know, in the total criminal justice system. And that is prosecutors and public defenders or defense attorneys get the same amount of funding. What are your thoughts?
Yeah, I think that's a good start. And this question reminded me that when I entered law school, my 10 closest friends, first year, all of us said we wanted to go in and do public defender type of work. And as it turned out, only one of us wanted that profession. And it largely was because of the amount of salary you could get being a public defender versus doing other things. I just looked up in San Diego what the average pay was for a public defender and a DA. And it goes to your point, David. The average pay for a DA is $126,000 per year. The top earner for the public defender in San Diego is $123,000 per year, with the average being $76,000. So I think it's about salaries and it's about resources. I think if you did that, we know at all levels of and all different types of trials, both civil and criminal, that if you have an attorney, you have a much better chance of getting a better result. So we know that. So yeah. And I guess I'm not sure how novel these ideas are. There are some communities that students you can look up, Oakland, Minneapolis, Portland, who are experimenting with some crimes with restorative justice models.
Mhm.
I know at USD, we're doing more restorative justice. I think a lot of students in our high schools now, this is something that when I was going through high school and college, we didn't really have that term. We weren't dealing with that. So I think thinking about ways that we can deal with folks who break our laws and norms other than the criminal justice system. And another idea is just like, to get at the recidivism rate, I mean, to think about reentry programs for folks. I mean, there is coming out of prison or jail. It's very hard to find a job. It's very hard to find housing, and you're very likely to commit crimes again to try to get by. So maybe thinking more about the reentry process for folks who have served time. Yeah, that and the restorative justice. Those are my two, I guess, novel ideas.
Anyone else with a novel idea to make our system more equitable, accessible?
I mean, glibly, I'd say make sure you make sure you regulate the large firms and say 33% of your attorney's business activity is going to be pro bono. I mean, we regulate all kinds of industries for various public goods. So maybe we should regulate the lawyering world and require large firms to do an elevated sense of pro bono.
Yeah, I don't. I think that the image that is the one that I tried to get across to my students is saying that you get an attorney means you get to be on the field in that adversarial system, but it doesn't mean that you're going to play football 3 against 11.
Yeah.
And how do we? Because we know that doesn't produce good football, and I think we all know intuitively that an imbalanced system doesn't produce good justice. We're not actually safer if we convict the wrong people, both individually and systemically. If we're convicting the wrong people, we are both leaving individual criminals on the street, and we are building a sense of anger and disenfranchisement and disempowerment and injustice among a huge community. And you know, this gets into Unit 6. This gets into a whole bunch of other units. But when you talk about fundamental rights, and right, we started with Professor Moore reminding us that we've been talking about jury trials for centuries in the tradition that we're part of for a reason, right? That we have faith in people's ability to make their case in front of their peers. But the facts have changed. Again, Professor Kerr talking about how, whenever the facts change, we need to adjust the system so that we continue to produce just outcomes. We can't rely on antiquated versions of what the Fourth Amendment or Fifth Amendment might have said. This is why the originalist argument is going to be really tricky, because right now we have a Supreme Court that finds the originalist argument really appealing. I'm not sure that I want to go back to a criminal justice system based on what was the tradition in the late 1780s and 1790s, because that's not the reality that we're in.
Well, they're originalists when it suits them.
Yeah.
When it's convenient.
Yeah.
So, gentlemen, as our tradition, as we wrap up our hour together, or a little bit more than an hour, is to provide final thoughts and recommendations to students and teachers as they prepare for the Unified question and national finals. So, Professor Moore.
Yeah, I found this this was wonderful because I have I have very little knowledge of any of this stuff tonight. But as I was sitting, especially that segment on the discussion about all this AI and applying technology to decision making on the front end and during and after the legal process, I'm fearful that I share this concern of turning over this unbelievably human effort of figuring out justice. I'm fearful of algorithms doing that. I mean, there's a tremendous loss there. Now, that's not to say that the human rehumanizing it. Thank you, Sting. Rehumanize yourself. That's not to say that humans are batting 1,000 either. But maybe I'm naive. Maybe you may call me a dreamer. That humans have a fundamentally important piece here that I for one am very unwilling to abandon in the sake of consistency and efficiency. The world that's presented by all this technology, it's a dehumanizing thing, I think, and I think we lose in the long run there.
Professor Gunn.
Every time you get a new phone or perhaps a new connection to the broader world through your home or your car, you sign away that little box. There's a box. Sometimes it's a box that if you have to opt out. Otherwise, the presumption is that you're okay with that company, that entity, accessing all of your data and all of your usage and commoditizing it and selling it to help make money. I think that we would be wise to discourage a sense, particularly among young people, that making your first call is so important that not reading that through and thinking about it, and maybe we could make those documents a whole hell of a lot simpler. Get it on a single 8x11 sheet with big block letters saying this is the 3 things that you need to. But there is an atmospheric shift in the willingness of people today to quickly check a box, giving up their privacy rights. And I agree with what my colleagues have said about the importance of preserving those. Mr. Cohen, Andrew Cohen, who did the interview that I referred to earlier, said the law is always catching up to technology, and the speed that it does so is determined by the Supreme Court. So we will see what the Supreme Court can do to help us as we navigate this difficult path as well.
Professor Williams.
Yeah, I would say that I'm super glad I'm not preparing this question and that the students are, because this is a big question. I mean, the Venn diagram of the criminal justice system and this sort of technology system that we've been trying to describe as the flops only can. There's a lot to process there. I would say that I often think whether systems, any system, like in this case, the criminal justice system, are there bugs in the system that we don't like, or are those things actually the features of systems? Like, I really believe systems provide what they are designed to provide. So a lot of us were critical of the current criminal justice system in terms of maybe who is disproportionately impacted by color or by wealth, the use of technology. We had that debate. And I would have students think about whether what you think is wrong with the criminal justice system today, whether that's a bug or a feature, and then to really lean into then how is technology, even if the technology is supposed to play a role of equalizing or providing more equity, to really think critically about, given the system as it has originated, or as it has developed, whether that's really going to be possible, or whether the same features of the system, I would argue, are features of the system, that this new technology is just going to be used to reproduce that. And I think Peter brought up a great point about technology, facial recognition, and all the problems and issues that we know have been with that. And that's just one small way that technology is being used. But I think it is slanted in a way that I think this question gives you an opportunity to delve into. So good luck.
Professor Kavanaugh.
Well, when Tim was talking about the human element, it made me think of something that was making the rounds on social media. The gentleman was in his 90s and he was before a judge, and he was having to take his adult son to an appointment. His adult son is a special needs young man. And the judge was talking to the older gentleman. I mean, he's in his 90s and he's still driving because he has to, because it's the only way he can get his son to his appointments because his son does not drive, and his son obviously struggles to function in society. And the judge was so kind to this man and so understanding of what he was going through. And I'm afraid that if we, and yeah, and conversely, yes, I know that we have overzealous judges, we have overzealous prosecutors. They let their own biases come in, but we also have backstops for those as well, right? Through the appeal process, I hope. But I'm fearful of taking the human element out, because you lose the ability at that level to understand that not everything is cut and dry that perhaps algorithms may see them as. And that's what concerns me. And I've said this, I'm glad, Peter, you must have been sitting in my classes, because I've said this for years. Our laws do not keep pace with our technology. They never have, and they never will. Thankfully, we have some younger people on the court, but if you think about it, at one point, you have people on the Supreme Court that had never sent an email that are actually making decisions about the email process. I mean, it's kind of crazy that our laws lag behind, but it's not that crazy when you think how rapidly technology advances. So rarely have our laws kept pace with our technology, and they probably never will, simply because of the nature of it. I would challenge the students on this to really, again, technology in terms of such a broad area, and you're going to have 10 minutes to discuss this. Good luck. Good luck.
Oh, well, again, this is a topic we could go on for a while longer, obviously. We want to thank Professor Gunn for joining us again for this session, and we look forward to having Peter back here in the month of March to talk about, I think it's affirmative action, and I am curious how that question ended up in Unit 5, but that's going to be a fun conversation there. And I've come to this observation about Professor Moore, and that is, if you believe in time travel and reincarnation, if you go back to 1785, you will find him in Western Pennsylvania. He seems to have a very serious love affair with the state of Pennsylvania in the 1780s, there kind of thing. So, in our next session, please let your Unit 6 colleagues know that we'll be talking about the topic of civil disobedience as part of our historical democratic society, and how we attempt to resolve or reform problems there. Until then, peace, love, yogurt, tacos. Bye bye. Bye bonds.